to start with the meeting now. Hello, ladies and gentlemen. Good evening. My name is Harshal Bhale. I'm a student convener of the Center for Study and Research in Intellectual Property Rights and a final year student of BLE at National University of Study and Research in Ranchi. On behalf of the center, I extend a very warm welcome to our honorable dignitaries, respected faculties, participants, and students to the Symposium on Intellectual Property Rights organized by Center for Study and Research in Intellectual Property Rights, that's CSRIPR, which is one of the most prominent centers working in the realm of IPR at National University of Study and Research in Ranchi. And this center was established with a noble vision of creating a forum which inculcates a culture of effective research in the field of IPR. So for this learning program, we are extremely honored to have with us Mr. Vivek Ranjan, who is Associate Partner at Singh & Singh Law Firm, Delhi, as a keynote speaker who is expert in the realm of IPR. I would also like to take this opportunity to thank the faculty convener of CSRIPR, Dr. Murthy sir, and faculty advisor, Dr. Shamla ma'am, for their constant support and continuous guidance to organize this excellent and learning program for the students of not only of our university, but also for the students pursuing their law degrees from the other universities as well. Also, I feel extremely honored to introduce you all to the brilliant panelists for today's symposium that we have with us today. All the panelists are currently associated with CSRIPR as an intern for the month of February 2022. The first intern and the panelist that we have for today's symposium is Ms. Jasbir R, who is a fourth-year law student at Geetham School of Law, deemed to be a university, Visakhapatnam. The second panelist is Ms. Shruti Kukreti, fourth-year law student at Fairfield Institute of Management and Technology, New Delhi. The third panelist is Ms. Bandhana Saikia, who is a third-year student of law at Symposium Law School, Pune. The fourth panelist is Ms. Bhashvi Saxena, who is a fourth-year law student at Jamia Islamia University, New Delhi. Last but not the least panelist we have with us is Ms. Anusha Mohapatra, fourth-year law student at Symposium Law School at Hyderabad. So I welcome all the panelists for today's symposium. Just to give a roadmap of how this program would go. So basically, each speaker will speak for a total period of 8 minutes. Then the question will be asked by the judges. Once all the panelists are done with their discussion, audience can ask their questions through chat box, which shall be answered towards the end, if time permits, due to the time limit we have scheduled this program. So we will keep in mind, if we get time, we will definitely try our endeavor to to give the answer to the question which is put forward by the audience who are here to learn something about IPR. Also, general address shall be given by our keynote speaker and the faculty chairperson after the Q&A round. And finally, we shall announce the award for the best presenter towards the end. Right. Also, I request all the students participant to kindly switch on their camera, but do not unmute yourself until it's asked from you. Now, without making any further ado to this learning program, I would like to call upon the first panelist for today's symposium, Ms. Shruti Kukreti, who is a fourth-year student of Geetham School of Law. Shruti, the floor is yours. You can start.
No. Jasbir is from Geetham School. Shruti Kukreti from Delhi.
Yes.
1 second. I'm so sorry. Shruti Kukreti from Fairfield Institute of Management and Technology, New Delhi. Yes. Apologies for the mistake. Yes, Shruti, the floor is yours.
Am I visible and audible?
Yes, you are.
All right. So, very good evening, CSRIPR, respected dignitaries, respected ma'am, sir, and my fellow mates. I, Shruti Kukreti, having applicant code TS75L43, will be presenting on the topic IPR and renewable energy. As I know that when it comes to renewable energy and correlation between IPR and RE, I think the role of patents is major. So I'll be focusing on the role of patents in development of renewable energy technology in this presentation. So starting it with a very good connotation that Paryavaran Sanrakshanam Sanskrit Suvichara. That means environmental protection is the best thought of our Asian culture. As we all know that climate change, it's a very global challenge, and we have international commitments to reduce greenhouse gases under Paris Agreement. And there is a need of global energy revolution and transition. So we need innovative technologies to help us meet the challenges of reducing our dependency on finite natural capital resources. So the development and deployment plays a very important role to replace all non-renewable forms of energy with more sustainable energy solutions. Now, patents have facilitated the development of such innovative technologies and continues to be the catalyst for this transition. Now, how it continues to be, act as a catalyst for this transition, that I'm going to discuss in this paper. So as we all know, dignitaries, that patent a very important domain of intellectual property rights. What are patents? As we all know, private and exclusive rights that are given for the protection of intellectual creations to patenter or inventor. It's a time-limited exclusive right given to the creator, allows inventors the ability to, restrict, use, sell, making the new invented products or processes, encourages innovation, drives investments, successful commercializations of intellectual creations. And it has been seen in the empirical evidences that jurisdictions having strong IPR have development and diffusion of technology. But when it comes to weak IPR, reduced innovations, reduced investments, and prevents potential firms from entering good markets. Now, this is a very basic life cycle of technological life cycle, that how patenting and licensing is done. As we all know, that patenting requires, mandatory public disclosure of information, and this mandatory disclosure of information allows others to see, understand, improve, and thereby spurs continuous innovation in the technological field. So therefore, patent system, through providing this economic incentive, is a successful tool which has encouraged the development and dissemination of technology in this sector. So as we all know, energy is a prerequisite for everything that, be it biotic or be it abiotic component, energy is a prerequisite in every aspect. But non-conventional and renewable forms of energy are more sought. Why? Because they are naturally existing. They can be replenished. So innovative RATs, if we talk about, they have the ability to create and tap into these sources and convert them into such energy which can be stored, distributed, consumed at a very competitive cost. RATs have developed into technologies which consist of alternative energy productions and energy conservation and green transportation. Now there are mainly 6 sources of renewable energy, like wind energy, solar energy, hydropower, bioenergy, geothermal, and ocean tidal energies. So if we talk about all the sources, I think wind, solar, and hydropowers are leading. They are leading the world and they are in the top list. When it comes to geothermal or ocean energy, it is relatively less. But if we see the statistical data, it says in 2016 renewable energy accounted for 12% of final global energy consumption, and in 2018 the renewables being used to generate 26% of the global electricity. The source of this energy was again wind and solar energies. And for the period of 2010 to 2019, we can see that there has been an investment of $2.6 trillion in renewable energy, and which were majorly focused on solar energy. And that too was driven by a private sector, which surpassed the investment that was made in traditional fossil fuel energy that were non-renewable resources of energy. So let me talk, we should discuss about the reports that have been given by International Energy Agency or World Intellectual Property Organization and International Renewable Energy Agencies. So this International Energy Agency, I think IEA doesn't need any introduction. It is the intergovernmental organization based on Paris and deals with usually the cases of oil crisis across the world. So the report reveals that there has been a significant increment in public budgets for energy technologies and research and development, and there has been a big increase in low carbon sector. Now, this trend in investment has also coincided with the increase in patent technologies in renewable energy compared to fossil fuels. And if we see the data, it says that European Union, United States, Japan have been the largest investors in development of RETs. Now, reports from WIPO, again, it doesn't need any introduction. A very specialized agency of UN under the flagship of United Nations Economic Social Council (ECOSOC) and headquartered in Geneva, Switzerland. The reports of WIPO shows that there has been a steady increase in the patent filings in RETs since mid-1990s, and this increase has occurred in majorly 4 renewable sectors, and that is wind, solar, hydro, and where these RET applications were steadily growing from 2005 and they reached a peak in 2013. But if we see the data, there has been a slight decline in 2013, but overall there is an increase. There is an increment. And if we see the wind sector has highest intellectual property ownership and patent grants as compared to the biofuel. But the report reveals that there has been dominance of patent filings of solar technology. Now I have one. This is a bar graph. The source of this bar graph is it's IRENA, the International Renewable Energy Agency, as I told you. So it's, as we can see, that this bar graph is showing the dominance of solar patent filings in the entire sector. And if we see this data again, this source for this data is UNEP Center, United Nations Environmental Program Center, again an global you can say global organization that deals with the problem of renewable energy and environmental protection activities. So as we can see, China and Europe, they are emerging as leading, they are emerging as global players and leading the lists of I think the finest players of renewable energy technologies. Now, I was talking about the WIPO report of 2019. It has shown that there has been 76% of all PCT patent applications which have come from United States, Germany, Japan, Republic of Korea, and China. And China is the newest entry. And it is in the top 10 list that has made one of the largest jump to one of the biggest R&D patent filers at Patent Corporation Treaty. And China is heavily investing in solar technologies and have filed numerous patents in this area and underlying technologies. As we can see the data, the pie chart also reveals the dominance of China in the investment. So interpretations, what are the interpretations taken from this WIPO report? It says that yes, successful flow of investments needs strong presence of IPR system in protection. Government policies and initiatives, they were very important so as to drive capital and investments into this area and to promote the development of RETs. Emphasis has been laid on the government policies. Now, direct effect of RETs through policies was shown in one of the very famous program of United States, that was Green Tech Pilot Program, which was based on the principle of green IPs, and it was a specialized accelerated patent application program which was developed by United States Patent Trademark Office for invention falling under the green technology category. And this program ran from 2009 to 2011 and led to the boost in RET patent applications, with office issuing almost 1062 RETs patent from the program. And if we talk about other jurisdictions, European Union and China, they have emerged as great players in this field and use their policies and incentives to promote the development of RET. Now let's talk about European Union and China a little more. Now, for the past 3 decades, we have seen that European Union has been at the forefront of the development and use of RETs and its leading innovation. European Union, they earlier set the targets which led to the increase in patents in wind and solar energies, and placing of European companies as global leaders in the development of RET is possible today. Europe is one of the largest source of foreign direct investments in renewable energy. 1 out of every 5 low carbon inventions originates from Europe. 2/5 of the high value patents with most economic potential and thus patented in multiple jurisdictions are all European. European Patent Office, I think it's the most sought patent office. Out of 6 of 25 global leaders of renewable energy companies are all European. So, what is the reason behind this success? I think the reason, as per my research, the reason which I saw were the continuous ambitious regional policies that they made, the incentives which sought to commit adhering to the climate change and sustainable energy transition goals, coupled with a strong IPR system. And the strong IPR policies both at regional level and amongst individual countries, as well as maintaining innovations in RET, have resulted in European Union meeting its ambitious environmental and climatic goals, as we can see it today. Now, this success has been achieved not only by encouraging the innovation, but also by making RETs more accessible and affordable, which allows the successful commercialization and adoption of these technologies. Now, while talking about China's success story, emerged as a global leader, largest market for renewable energy, I think we all know that. So, they are the leading producers of wind energy, solar energy. In 2017, the data says that China produced almost 25% of the world's wind energy and increased its share of solar PV. The largest manufacturer of certain key components in RET, and almost 5 out of every 6 largest solar module, if you see, and wind turbines manufacturers, they are all Chinese companies. If you talk about the data of 2017. And if we talk about the data of 2019, they are the largest inventors of, I think, renewable energy, amounting to USD 83.4 billion investments, or you can say 23% of the global investments are all from China. Largest patenter of RETs during the period of 2017 to 2018, holding a cumulative 29% of the global patents in 2016. So this is the China's success story. Now, again, why this success? What is the reason behind this, amazing success? So, sir, it's actually the China's policies. They have focused more on technological innovations and research and development. The WIPO patent data shows that China is the largest holder of, I think, patent families, and which indicates that the Chinese companies are patenting across more jurisdictions, and these investments have more commercial viability. Now, RETs are amongst the list of product and technology Chinese companies that are incentivized to import into China. And this part of government to, plan and acquire RETs and present a valuable opportunity for foreign firms to form a strategic partnership, and thus inviting commercially active markets into their jurisdictions. So China's rise also indicates that there has indeed been a global shift towards renewables. And in the past years, the cost of REDs has also, it has fallen for easier access and demand for electricity produced by REDs. Now, if we talk about the South Asian countries and African countries, there has been success. There has been some shift, like large-scale wind and solar projects have replaced the traditional fossil fuels energy projects in many, like India is one of the example of, I think, South Asian countries, which is doing some great things in this sector. Now, the empirical evidence shows that strong IPR system along with very good environmental policies have ensured that there is appropriate technological transfer and diffusion. So what are my suggestions? My suggestion of this entire research is that the government policies which support IPR, they have direct impact on the advancement of REDs. Therefore, I strongly feel that government should continue to support more IPR-friendly policies, like offer tax incentives or easy financing options, or easing barriers, as this will result in necessary research and development technology transfer by providing a return on investments, legal support, protection necessary for continued private sector investment. Strong IPR system is very important for the faster technology development through partnerships, strategic partnerships, which China did, encouraging private firms to invest in R&D in the developing world and finding innovative local solutions to country or region-specific challenges. And strong environmental policies, laws which penalizes and discourages the investment in fossil fuels or any non-renewable energy, and as well as increasing the regulation on these industries, on providing positive incentives and R&D innovations through the use of grants, loans, tax incentives, or subsidies. Like Denmark is a very good example if we see, and it stands as a testament of successful environmentally friendly industrial policies which they have embarked upon since 1970s, and they have ultimately emerged as world leaders. So dignitaries, I need to quote one verse from Chanakya Niti, that उद्यमेन ही सिद्ध्यन्ति कार्याणि न मनोरथे न हि सुप्तस्य सिंहस्य प्रविशति मुखे मृगा. It simply means that in order to be successful, in order to yield good product, just thinking is not going to help us. We need to take strategic actions. We need to take steps in order to ensure and develop more. So my conclusion here says that indeed there is an urgent need to innovate and deploy the necessary technologies which can face the challenge and avoid the negative economic and social consequences of climate change. As each country and region, they pursue their own renewable energy goals, due in part as commitment to fighting climate change, but also it is acting as a means of securing their energy independence, and it is also providing them economic development. So it's a very good arena. Now, thus, it is very important, it is very imperative for all the countries, I think, to accelerate the adoption and creation of REDs. And we should recognize the Article 7 of TRIPS agreement. And it would be correct to say that IPR has indeed played a crucial role to the technological revolution, affecting all aspects of life, and will continue to be a major catalyst for this energy transition. Now, dignitaries, I would take one shlok from Srimad Bhagavad Gita, verse 2.22, which says that Vasansi Jirnani Yatha Vihari, Navani Grihanani Naropanani, Tatha Sharirani Vihai Jirna, Nayani Sayanti Navani Dehi. Dignitaries, I request you to not go into the literal meaning, as it would create some chaos, but I want to, I want to make you all understand the meaning of this stroke in a very deep sense, which says that in order to be truly successful, the sustainable organization needs to continuously engage themselves in discarding old ideas, old mindset, and embrace new ones. I think this is the fundamental building block of innovation and creation, which will further lead to the development of entire mankind. So, dignitaries, I think my ideas and my suggestions are crystal clear, starting from a very positive connotation and ending it with a very beautiful connotation. I think my message is again very crystal clear, that we should understand the role patent plays in the developments of renewable energy technologies, and we should adhere by our principles of sustainable development by improving and giving good improvements and providing good policies for the development and improvement of patents, and recognizing that yes, good patenting and strong IPR policies are very important for technological innovation. So ultimately, this brings me to the end of my presentation, and a big thanks to all of you for bearing with me. Thanks a lot. Thank you.
Thank you, Shruti, for your great presentation. I would just request all the panelists to please have a look onto the chat box also, because we have a limited time and other members are also there. So please have a look on that, and then we can proceed accordingly. Thank you, Shruti, for your presentation. The next panelist is Ms. Jasbir R. Reid, fourth year student of law at Geetham School of Law, Visakhapatnam. Jasbir, the floor is yours.
Thank you, sir. I'll just share my screen, sir.
Yes, the screen is visible. Please proceed.
Thank you, sir. I, Jasbir R, the fourth year BLLB Honours student of Geetham School of Law, wish the dignitaries, faculty members, and members of CSRIPR and my co-interns a very good evening. Today, let us have a look at how granting patent or IPR protection to fintech, whether it's a boon or a bane to the environment. Let's see what this question brings the answer to. Now, what are we going to do in the next 4 minutes? In the next 4 minutes, we're going to see what we're talking about. Then we're going to go ahead and see what the environmental impact of fintech is. Going ahead to look at what the benefits of granting IPR to fintech are. Then going ahead to look at how blind IPR protection can incentivize the fintech industry, the unsustainable fintech industry, and aggravate climate change. And then let's see what the answer holds. Now, firstly, what are we looking at? We're looking at a fintech industry that is unsustainable to the environment and a threat to the environment. And considering this, blindly granting IPR protection to fintech can aggravate the environmental threat. And this is why this presentation analyzes what may be the way forward. So firstly, we're going to answer 3 questions. The first one is how the various international environmental agreements are rendered merely on paper by the unsustainability of the fintech industry and how this is aggravated by the blind grant of IPR protection. Secondly, we're going to look at what is the threat to human rights posed by the fintech industry, such as the Sustainable Development Goals, Agenda 2030, etc., in relation to the environment, and how this is aggravated by the grant of IPR protection. And the third question we're going to look at is what is the way forward? What's that big answer in navigating these 2 issues which I've just raised in relation to IPR protection being granted to fintech innovations? Now, let's dive into the environmental impact of fintech. Is fintech harmful to the environment? Yes. Why? Why do I say so? I say this because looking at statistics and studies, we see that there's high reliance on fossil fuels and large quantities of e-waste. What does this mean? According to Sierra Club and the Center for American Progress, we see that the fintech industry is the 5th largest emitter of greenhouse gases, and if it were a country, it would be the 5th largest emitter. And according to Ben Cushing, manager of Sierra Club, we see that the fossil fuel investments of Wall Street, he says that they are a threat to the future of the planet, putting many people at risk, especially vulnerable communities. Furthermore, 8 banks in the US invested a lot in fossil fuel-based investments, and that is the reason why these are equivalent to 668 million metric tons of CO2 emissions, which are like 145 million passenger vehicles driven for 1 year. So that's a lot. Now, what's another problem? Another problem is the lack of transparency of energy consumption. So banks don't disclose where they are giving their investment, where they are granting loans to, and this is also a problem. And US banks and 10 of its largest asset managers together, they finance 2 billion tons of CO2 emissions, and these emissions excluded the emissions produced by their supply chains and customers. So this exclusion is a lack of transparency. Then we see e-waste, credit cards, debit cards, all made of plastic. and the need of powerful computers, other electronic devices by the fintech industry disposed of quickly. All this is a carbon footprint. Now, consumerism. Yes, there's a lot of liquidity to money we see because of the fintech industry. We can make payments in a fraction of seconds, and all this causes us to want to buy more. Our wish to want to buy more is the demand. Then there's need to produce more, and the need to produce more causes more pollution, more emissions, and production. We want it, so it needs to come to us. So transportation over long distances, that's even more bad for the environment. Now, what about cryptocurrency? Cryptocurrency, we all know, is the talk of the town nowadays. Alex de Vries, a financial economist and data analyst, what he spoke about was that the mining activity requires specialized machines, proof of work algorithm. It draws a huge amount of electricity, which is not sustainable at all. Countries like Iran, Kazakhstan, and Kosovo have had energy outages due to the mining, and the total energy consumption of the Bitcoin network is estimated to be equivalent to that of Thailand, and the e-waste is equivalent to that of Netherlands. Now, what are the benefits of granting IPR protection to fintech? Long story short, IPR protection to fintech is definitely going to incentivize fintech, is going to make it better, is going to make it grow better rather than better in sustainability. So because of the protection granted to corporates, etc., corporates are incentivized, they get their patents, copyrights, trademarks, trade secrets, etc., and fintech grows. How can we use IPR protection to grow sustainable fintech? Let's go ahead. Now, what we see is Article 7 of the TRIPS agreement. According to it, the promotion of technological innovation and transfer and dissemination of technology to the mutual advantage of producers and users of technological knowledge, and in a manner conducive to social and economic welfare and to a balance of rights and obligation, is the goal of IPR protection. And this is attained by the financial sector. Also, in a case, Biswanath Prasad Radheshyam versus Hindustan Metal Industries, the Supreme Court also threw light on the objective of patent, saying that it is to encourage scientific research, new technology, and industrial progress, etc. So all this is attained in the financial industry by the grant of IPR protection to fintech. Now, let us go ahead and look at what blind IPR protection does when it's granted to fintech, and how does it aggravate climate change. Looking at the sections we looked at before, we can construe that the environmental impact of fintech and blindly granting IPR to it incentivizes the industry and helps it grow. And if this is blindly granted to fintech, it exacerbates the issue of climate change and harms the environment. And now let's look at some international goals aiming at environmental protection and sustainable development ahead. We look at the Paris Agreement. What's it for? For a 2-degree limit, governments need to look into that and limit the global warming to 2 degrees C. However, according to Alex de Vries, whom I quoted before, he says that Bitcoin alone could rise the global warming to 2 degrees C in the next 30 years. How sustainable is that? Now, we need to decrease greenhouse gases, mitigation and adaptation. Will all this be possible with blind IPR protection to fintech? No. Now, what about the Sustainable Development Goals? Good health and well-being. Can people, especially vulnerable communities, have access to good health and well-being given the environmental impacts of fintech like water pollution, soil pollution, etc.? Clean water and sanitation, the same issue. Climate action. Can this allow proper climate action? Life below water. I've already spoken about water pollution. Landfills, life on land. Is all this protected? We see that the Sustainable Development Goals play a crucial role in combating the climate crisis, and they help in protecting and conserving the environment left today by introducing and building new technologies which apparently make human life easier but are actually prejudicial to the environment. I'm talking about unsustainable fintech. We are rendering these SDGs merely principles and resolutions on paper, but never or partially followed. Now, let's go ahead and look at what this 2030 Agenda for Sustainable Development talks about. 2030 agenda is an agenda to implement the sustainable development goals. So if the sustainable development goals are defeated, the 2030 agenda itself is defeated. Can we achieve this better world which the SDGs and 2030 agenda aim at, given the anthropogenic development we continue to bring upon Mother Earth? No. Furthermore, looking at also human rights, the UDHR, right to life, liberty and security, can I be granted the right to life if the pond beside my home or the well water is polluted? No. Right to standard of living adequate for health and well-being. Will I be healthy if it's polluted? No. Inherent right to life of every human being. This inherence is lost. Adequate standard of living. All this is lost. So can we ensure human rights given the current environmental impact of the fintech industry? No. So what's the way forward? We've reached what the big answer is. Let's see. What's the way forward? Because IPR protection incentivizes fintech and helps the industry grow, IPR protection must not be blindly granted to fintech innovations. Why do I say so? I say this because only when unsustainable development of new unsustainable fintech technology is not incentivized.
Ms. Reid, you have overshot the 8-minute threshold. Now you just have a minute or two to wind up the conclusion.
Yes, sir.
Yeah,
sure. Yes, sir. I'm winding up. Yes, thank you. So when we stop unsustainable development by not granting it IPR protection, only then will the old ones become sustainable and the new ones be developed in a sustainable manner following the sustainable development goals and those standards set by the UN. With respect to cryptocurrency, it mustn't be granted IPR protection because of the reasons I've already thrown light on, and instead it must be protected due to various reasons. And also, when implementing any innovation, we need to stress on the precautionary principle, which basically says, look before you leap. And we also need to look at the polluter pays principle by taxing, penalties, damages, etc., so that the old unsustainable fintech can grow sustainable. Furthermore, the principle of intergenerational equity also needs to be looked into because we live for another, say, 100 years, and what about the others? Are we going to bring rot on them? Now, we need to change the goal of technology from making human life easier to environmental protection and conservation. All our technology innovation must keep this in mind and must be majorly used for this. We need to build awareness of environmental protection and the inherent value of our environment. We need to begin by treating our environment as Mother Nature and allowing her inherent value rather than allowing only ourselves our inherent value and treating her as a mere resource or as a mere thing. So I conclude by saying that as long as we continue this so-called development we keep bringing upon ourselves, which excludes other living beings and elements of nature, we are spelling disaster. Thank you.
Thank you, Jasbir. Now the next panelist we have is Ms. Bandhana Saikia, who is a third-year law student at Symposium Law School, Pune. Bandhana, floor is yours.
Am I audible and visible?
Yes.
Yeah.
Excuse me. Before you start, I'd like to point out that try to keep a track of the 8 minutes allotted to you. See, I know that while having the presentation going on, it's not viable to look at the chat box. So when the 8 minutes will be on approaching, the end will be approaching, I'll give you a prompt. So that way you'll be knowing. Fine.
I have put a timer in my phone.
That's great, but still, I thought in case.
Yeah, sure.
So
Thank you so much. Thank you. Is my screen visible? Is it visible?
Yes, it is.
Yeah. Good evening to the esteemed panelists and good evening to all my fellow co-interns. This is Bandhana Saikia from Symposium Law School, Pune, currently pursuing my third year of BLLB honors. So a couple of days back, we had a very healthy discussion with my fellow co-panelists about what is constitutional morality and how can we relate it to IPR. So going back to what exactly is constitutional morality, I guess constitutional morality and IPR may seem like a topic which is very distant, but it definitely has got something to do with intellectual property, as because constitution is the law of the land. So when we talk about constitutional morality, it means adherence to or being faithful to bottom line principles of constitutional values, which may be right to equality, right to freedom of carrying on trade, business, and other fundamental rights and preamble protected rights. So we see that the concept of constitutional morality is not limited to what exactly is quoted toto in our constitution. We have seen there is a shift from literal interpretation of the constitution to the golden rule of interpretation of the constitution, where post Menka Gandhi era, we saw that the judges of the Supreme Court have turned their interpretation of the constitution in a more liberalistic approach, taking into consideration of the morality aspect of our country. So we see there's a proper blend of natural law and positive law that establishes a just society, because we cannot discard one natural law and then take up a positive law and vice versa, because the blend of both would actually lead to a proper justified society. So when we talk about constitutional morality, it's not specifically mentioned in the constitution, but we can largely confer the same from the interpretation of the fundamental rights, direct principles of state policy, preamble, and fundamental duties. So the topic that I chose for my panel discussion was basically on trademark. However, I wanted to make sure that I cover all my fellow panelists' points into my core presentation. So we see that there is a lot of changes in constitutional law as per the moral needs of the society. We saw the Sabrimala Temple case, abrogation of Section 377 of IPC, and the upholding of right to privacy. Starting with how intellectual property has a constitutional perspective, though we don't have it specifically mentioned in our constitution that constitution protects intellectual property rights, but we definitely have something to do with property rights. So as we all know that it was a fundamental right guaranteed under Article 31, however, it has now been shifted to Article 300A, which protects every person's intellectual property, and it can be inherently or could be indirectly understood from the same. So taking into consideration of the first, constitutional morality and patent. So we know that everybody must be definitely knowing what is the patent. So I won't take much time on that. So we see that how constitutional morality and patents are in picture. So my fellow panelists discussed on that day that it relates to the right to affordable medicine. So for instance, right to life has incorporated a lot of rights, including the right to live a healthy living life. So we see that it includes the right to medical care as well at an affordable cost. And in any case, any life-saving medicine was not affordable, then it is imperative for the state to grant a compulsory license for making such drug available at an affordable cost for every section of the society. Further, if you see that as per Section 3B of the Indian Patents Act, the invention which are not patentable is when it is immoral or against public order. For example, it would be very surprising, as Shamna ma'am also discussed it a couple of days back, that a sex toys was to be patented. However, it's actually a true case, but it was not granted patent because it was seen as something that is immoral or not acceptable to the societal moral norms. Because it is an individual moral right that I, for my pleasure, I may use a sex toy. But however, whether it has something to mingle up with the society morality is the question that we have to answer. Further, we have the constitutional morality and copyright. So we say that the law of copyright enhances the value of speech and expression through writing of books, music, videos, because it gives effective protection to creative speech and expression, poetry, criticism, etc. But there is a clear mention that we have to here make is that what about if I want to copyright something that is obscene in nature? So that might lead to a very societal chaos where the society may not accept what I want to copyright. So there is an absence in the Copyright Act of 1957, a societal moral clause, whether a copyright could not be granted if it goes against societal moral clause. I think that is supposed to be addressed through the necessary amendment. Further, this is my favorite topic, constitutional morality and trademark. We see preamble respects our right to economic right. We have fundamental right under Article 19 to carry out trade and business. So we see that there is a blend of trademark in the constitution as well. So the most active area of morality-based impediments arises from the context of registrability, since Section 9 and Section 11 talks about the grounds on which the trademark would not be registered or the grounds where it could not be registered. So the thing where I want to discuss here is the Myntra logo. As we all are aware that a lot of controversy happened when it was connoted to portray the vagina of a woman in the Myntra logo. I think that's something that we all know. But it had to bend towards the public morality order. Then we see the Taiwan case. There was a Taiwan case known as the Gangnam Beer and Wings, where the Taiwan court granted a trademark to a restaurant owner who actually portrayed their restaurant logo as a man urinating. So even if it was a lot of opposition filed against them, but it was still granted because it was something that was proof that it's very normal. It shows that he's trying to just have a chill out time in the restaurant. Further, we have the consumer rights. So I guess we all believe that IPR is all about economic rights. So what about the public rights, right? So we have the consumer rights out here because protection of trademark also protects the interests of the citizens' right to information about what is the authenticity of the product they are using. Say suppose hallmark, agamark, etc. Then we come towards constitutional morality and trade secret. We see that Article 919(1)(g) prohibits monopolistic structure of business. So we see that trade secrets with utmost security can lead to monopolistic market. My friend really very well recommended about this. We know that if I want to just seclude one particular ingredient to only my company, then it would lead to a very monopolistic character which the constitution may not have envisaged when they created the constitution. Further, it also leads to unfair competition since we don't have a proper legislation to go ahead with trade secrets. And there is no concept of rule of law when there is an arbitrariness, right? So further, we have the geographical indication, something that is very least researched, but however we see that it gives a sense of protection to the local manufacturers who freely practice it under Article 91(g). Further, the direct principles of state policies also, although not enforceable, but they are complementary and supplementary to our fundamental rights, which states that we should guarantee economic justice to all the people. And there are a lot of WIPO reports which suggest that branding strategies using geographical indications can help farmers in the poorest countries, right? Then, coming to the conclusion, I think I don't have a proper suggestion, but I tried to address those loopholes, and now it's a part of us being the students of IPR and constitutional law, and all of us sitting in the center to think about it, since that while researching on this topic, we had very limited resources to look up to. So we brainstormed and we came to this conclusion that though there is no expression that deals intellectual property in the Constitution, but it is very implied through safeguarding fundamental rights, TPSPs, and other international treaties and obligations that we have under the Constitution. So that's all from my side, and I just wanted to make sure that considering I'm an IPR student, so we should definitely give credits to the sources that I have used here for this presentation. Thank you so much.
Thank you, Bandhana. The next panelist we have for today's symposium is Ms. Bhashvi Saxena, fourth-year student of Jamia Islamia University, New Delhi. Bhashvi, the floor is yours.
I'm sharing from my screen.
Yes,
Is it
it's
visible?
Yes. Okay. Please proceed.
Okay. So a very good evening to everyone. I'm Bhashvi Saxena from Jamia Millia Islamia, and I'm going to deal with the topic scope of petty patents protection in India and comparative analysis. So basically, petty patents are those patents which are provided for a shorter period of time for a small innovations. There is no universally accepted definition for the term. They are recognized by various terminologies such as utility innovations and short-term patents. However, in a generic sense, this model of patent is recognized as a utility model of patent all over the world. This model has been recognized under the Paris Convention of 1883. Utility model of patent is basically an intellectual property right to protect invention for a shorter term. Basically, it means a short-term patent, which generally ranges from 7 to 10 years. The basic idea behind adapting this utility model of patent is to protect the increments, innovations, and improvements in the inventions that do not meet the strict and sophisticated requirement of standard patents under the TRIPS agreement. So Germany was the first country to incorporate this model of patenting. The reason behind this evolution in Germany is that at the time of unification of Germany to form an empire in 1871 had created a major economic power blockage in the country. So to overcome this power blockage, they introduced the concept of patent law in their law for the first time in 1877. But the fees of the German patents were seen partially as a means to raise revenues by taxing foreign inventors So this has created due to this the fees for industrial designs were somewhat lower, and this led to the number of domestic inventors filing for the protection of their ideas as a design right instead of for more expensive and patent protection. So the utility model, which is evolved, set up is evolved in 1891. The commission was set up. The commission of inquiry was set up in 1886, which recommended and noted that the domestic inventors and industries required a minor degree of protection for lesser inventions and technical designs for which the cost of the time for prosecution of the patent could not be justified. So in June 1891, they came up with the concept of utility model of patenting. This model was also adopted by various other countries, like Japan was the first country to adopt this model in 1909, and followed by Australia, which became the first country to introduce a legislation in regards to petty patent in 1971 in their legal framework. Presently, about 70 countries in the world have some form of utility model of protection for the innovation, which basically focuses on the lower standard of inventiveness. So these are the characteristics of a utility model of patent. It is very advantageous for the smaller inventions as they need protection within a short span of time. It is very less expensive and easier to obtain as there is no process of examination or inquiry involved at the time of registering the utility model, the utility patent. It also provides quick commercialization of product in the market. It can also turn to be a source of income for small scale investors by granting them by granting smaller inventions, and royalties can earn royalties from that inventions. So the existing products can also be substituted in a very quick manner. The most important function of this utility model of patent is the functional aspect of the product. As there is an example, uh, just increasing the data storing capacity in phone from 16 GBs to 32 GBs, there is no new product, there is no new innovations has been created here, but just an increase in the utility and the function of that device. So these are few more examples. The most historic one is that this pencil and eraser. This concept, these types of small innovations can be easily covered under the utility model of inventions. So these are few examples. The storing is space saving hangers and saving furniture. These are the three essential requirements of a utility patent: novelty, utility, and inventive steps. Novelty and utility are just same as ordinary patent grant, but inventive step in a utility patent has a significant difference with patentable invention. Is that a utility model has an inventive step if a person with ordinary knowledge and skill in the field cannot easily carry out based on the state of art. So here, inventive steps do not require any professional or specific knowledge, but a person with ordinary knowledge can also claim utility patent. So I will be analyzing the utility patent models across the world. So European model was the first model of petty patents, as Germany was the first country to establish this concept in their law. European model is limited to the territory of its nation. And national utility model is available in European country. It has by inclusion of this model, it has encouraged 85% of domestic innovators to file application, which focuses more on novelty utility rather than inventive step. So utility model are registered with the German Patent and Trademark Office, and generally these patents are not investigated or examined before the grant of registration. This process makes it simpler and cost effective, due to which a huge number of applications are increasing. In Germany, 10 years, grants are to be made promptly without examinations for a period of 10 years. This is the Japan's model of petty patents. It evolved there in 1905, which basically based on the model of Germany only, but it was got amended several times and now it is restricted to the device systems only. The application under the petty patents are not examined substantially, and protection is granted almost immediately through registration and publication in Japan's system of petty patent. This is the procedure for obtaining a utility model under the Japan, and there is a significant decrease in the filing of petty patent in Japan after 1909 amendment, as they reduced the period of protection to 6 years, and the other legislation period of process itself is more than that period. So people starts avoiding this concept, and a huge fall in the applications was recorded. So, but now they are restricted to 10 years. Australian model is also somewhat just like similar to Germany utility model, but no exclusion of for processes was mandated in the Australian model. The Australian model has also evolved their concept by various amendments and other things. In Australian model of patenting, the requirement of substantial contribution is very essential, and this makes the petty patent process less stringent. The restriction in the number of claims for the an important aspect. The Australian law allows a maximum of 5 claims with no restriction on the type of claim. There is a case in Australia that the number of filings has increased very frequently. So to overcome this situation, they stepped of maximizing the claim. The beneficial for switch type claims where a new use of existing components or properties are discovered. So it can also help in protecting the traditional knowledge, like the Kani community case where they discovered the Arogya Pachak, and the tropical and the other research institute got it registered by themselves. So India is also heavily dependent on informal sector. Around 81% of the Indian economy is dependent on this. And also the filing of application from the resident Indians is very low in comparison to non-residents due to the economic availability in Indian context. So this system can help Indian peoples very much to change the mindset and encourage them to innovate new things. All these innovations are good, but they are also equipped with certain opportunities to be overcome. And these are the 3 basic opportunities which petty patents possesses. First is greater chances of revocation of patents. There is no substantive examination. Opposition generally takes about the third-party action after the grant of that petty patent. So this leaves the patent quite vulnerable to revocation, and that too after the patentee had most of the fees. Also, the shorter period of protection might not provide adequate time for the full commercial exploitation of the innovation by the patentee, and there is also the fear that utility model will create a parallel system which will result in the undermining of the patent process itself. So, in India's initiative towards including the model of patent is and creation of NIF, which was set up in 2000 by the Department of Science and Technology to scale up the idea of learning from grassroots innovators. It also it has indulged in the process of documenting many of the innovations that people have taken the initiative to create. Recently, there is also a development in the Rajya Sabha where a report number 161 titled Review of the Intellectual Property Rights Regime in India has recommended to look upon this matter. So these are few examples. This is a onion transplanter which is used to ease the process of growing onions. It performs 3 functions at a time, which requires a lot of human manpower before this. So it is a single machine which is performing 3 functions. Other is mythical, the traditional mythical fridge, which Indians use to store food for longer period of time. An automatic pump operator. This automatic pump operator is basically used for controlling the overflow of water and provide easiness to in day-to-day life in households. So my conclusion is that India should try to incorporate petty patent concept in its patent law, as such a system will ensure the grassroots level innovators to raise funds to work with their innovation and a legal framework to protect them from being copied. Although there will be chances that after the introduction of this model of patent, there can be a huge rise in the filing of application in India. But what about the people whose innovations are making a significant change in the existing society? However, to overcome this, we can also put certain restrictions on the claims over petty patents, just as the case in Australia. So, and the most important and the greatest advantage of this system is that necessary infrastructure which is required for the successful implementation of petty patent is already in existence in India. Hence, just by creating an effective administrative and legislative infrastructure, it can turn to be a fruitful measure in India's socio-cultural background. Inclusion of this system is a need of an hour in Indian context, as this system has already been recognized by various countries. And what if people from countries start copying and get themselves patented with the India's innovative creation, which is one of the biggest hub of these kinds of jugards. So with this, I would be ending my presentation.
Thank you, Bhashvi. The last presentation is, yes, Ms. Anusha Mohapatra, fourth-year law student at Symposium Law School. Anusha, please proceed.
Good evening. I hope I'm both audible and visible. I just share Is it visible now?
Yes, please proceed.
I'll just proceed. Good evening to all the dignitaries and to my co-panelists. I am going to present on the topic of open source from an IP perspective and how can we aim to successfully protect an open source software. Open source software primarily operates on the concept that the source code is publicly accessible, and that is sought to be protected as a literary work in our laws. For instance, the Berne Convention provides for the protection of such computer softwares as literary works under the Copyright Acts of countries, which led to an amendment to include computer softwares under the definition of literary works under Section 2 of the Copyright Act. Now, essentially, what is the primary benefit of us having such open source softwares which are publicly accessible is that there are diverse and large number of developers, which is one of the crucial elements that the founders wanted to emphasize on, that it had a sense of community, a nature of community to it, that it's accessible to a larger public and they can contribute a lot more. So again, but when I say that there are a lot more contributors, it does not mean that there's a complete lack of ownership therein, as open source communities agree that they are contributing to a common, they're not only contributing to a common pool, but they're also sharing the derivative creations. Now, when I talk about the sense of community, there is also an emphasis on common goals and a shared vision that people have when they go on to build such a software. And their own personal beliefs are also getting enforced. So when they go on to accomplish their goal. And although the programmers retain their moral rights, they do renounce their copyright to some extent, but they retain their right to be identified as an author. So such softwares find both wider usage, and they're also available in the public domain, and there are also associated freedoms with such an open source software. Conceptually, you can use, study, and modify them and these softwares as per your needs, and then you can also create derivatives to them. and they become extremely crucial to, and it's also extremely crucial to protect the integrity of your software. So when Richard Stallman introduced this concept, there was also another concept called the concept of copyleft, wherein such proprietary rights could be made public. And to implement the same, one of the such licenses is the GPU, that is a general public license, was introduced. So now such concepts of trademark licensing, when viewed in light of open source softwares, gives the proprietor a right to obtain license and to release it to the public. So there's like a pre-contractual agreement, and these pre-contractual agreements are essentially of two kinds. They are either permissive or restrictive. So permissive, as the name suggests, gives you the right to modify, adapt, or amend, and also posits derivatives, one of the examples being a patch 2.0. And a restrictive license like the GNU is where all the modifications need to get relicensed. Now there is a sense of coexistence of open source and IP that we need to look into. Every time that you want to operate both of these things, you need to monetize the software, you need to decide the licensing guidelines, and to see the contributions and modifications, you need to audit to check whether there is any scope for infringement of licensing. And it is also extremely feasible to go the open source way. The coming of open source softwares in India was by the Free Source Foundation, which is a sister organization to the Free Source Foundation, which was founded by Richard Stallman in 1985. And their objective essentially is to increase awareness and provide support on relevant documentation and guidelines, and also to promote local programs. Now, when we talk about such a concept, it's important to understand what are the examples that abound around us. So when I talk about audio, visual, or gaming, or all those things, there are so many ways in which they abound around us. A search engine like Mozilla Firefox, or a blog like WordPress, which is also used by NUSRL themselves. Then there is the PCSX2 emulator, which is the PS2 emulator, which also uses open source softwares. There's VLC Media Player, and there's also Python and other such examples. So these essentially, when we talk about such softwares, the rights remain with the owner, and your work also gets either protected through licenses or under the copyright. The only issue is that if there's no strong footing specifically created for this purpose, sometimes it may lead to renouncing concepts such as copyrights, patents, and trade secrets, since the software is fully reproducible. So you can also make it subject to a licensing agreement to protect it. Now, when we look at these concepts, it's important to also look at how laws have interpreted such a concept. So one of the case is of Jacobson versus Cancer, where the court held that a license is my presentation still visible?
Yes, it is.
Yeah, all right. So where the court held that a licensee's violation of the artistic license imposes disclosure requirements on the licensee as well, and that could amount to a copyright infringement. The issue in this case was whether this artistic license could impose a condition which would limit the scope of such license rights. Now, this case was instrumental to talk about how portions of software developed by an open source software group could, in this case, were copied, modified, and distributed by the licensee, and which it also emulated the conditions that should be set in such OSS license agreements. Similarly, there are a few other case laws which also talk about, since Google is one of the companies which also uses an open source software, there are a few other cases also that emulated on those grounds. The advantages of going the open source way is that you give there's like a divided sense of control, and also the fact that people can delete or alter parts which may be unimportant or unnecessary. And the flip side I'll discuss in the next slide. But it also helps with training. So when there are upcoming programmers, it helps you to learn faster when you get to see the source code and things like that. Again, it also becomes more affordable and stable, and it provides users with means and tools and content which do not disappear when you start working on it. And such open source is sometimes also confused with free software because of its nature of being publicly available. The terms are sometimes used interchangeably, but the distinction is that the source code of open source software can be altered or changed. In freeware, is also there's a sense of proprietary nature to it. Again, the disadvantages of such software is that sometimes if a third party claims that the licensee is using their code that the third party developed, the licensee has no one to pay his legal fees and damages to. And the authenticity of such an open source software also cannot be identified because it's alterable. I'll wrap up very quickly. So to conclude, there are a few things to note in such cases. Since software is copyright protected, it prohibits others from sharing the same rights as the owner, and these include the rights to decide who can adopt, copy, and distribute your work. The copyright owner in such situation can try to protect their copyright over that software by virtue of either a license agreement or to and they can also send out copyright notices because of the availability of the source code. If there's a failure in compliance with the OSS requirements, it may result in either legal action and there are severe complexities. Lastly, another challenge is that now there are a lot of software patents that are coming up which could pose a problem to such concepts of community where there is a source code that's publicly available. It's debatable as to how the future will lead when it comes to open source systems, but currently it's a very viable mode and it's helped a lot of companies come up with innovative ways. It provides a social welfare objective as well. And I think that continuing it in this way can actually lead to greater scope of both learning and I think increase usage. With this, I sum up my presentation. I would like to thank my teammates for helping me come up with all of this content and for this platform and to all the dignitaries for being so patient.
Yes, thank you, Anusha. And I would like to thank all the other panelists for giving their presentation. Now I would like to call upon the speaker, the keynote speaker for today's presentation, for today's program, Mr. Vivek Ranjan, sir, Associate Partner at Singh & Singh Law Firm, Delhi. Then Vivek sir will ask few questions to all the panelists, and then Murthy sir will ask the questions if he had, and then the best presenter award will be declared. Vivek sir, please proceed.
Hello everyone, it was glad to listen to all of you and your topics were very interesting. I just wanted to know a few things. This presentation was made based on your internship at the center, right? So I assume
Yes.
that you have worked in these topics and then you have made all this presentation, is it?
So basically,
Yes.
they were allotted with. So basically, they were allotted with the theme, whatever they have presented today, and 5 people from each group they presented, and best of these 5. Basically, 5 groups were divided, and each intern from one group was selected for today's symposium. So whatever they are presenting today has been already presented by the 5 panelists, and today they are coming up with all the points that had been already discussed in the panel discussion. Okay. Yes.
All right. Okay, so I'll start with Shruti. She talked about IPR and renewable energy. Shruti, what is your background?
So my background is law, definitely, BLLB, and I'm a 4th year student.
You're a law student.
Yes.
So tell me something. You say about renewable energy. What domain of renewable energy is actually patentable? We talked about a lot of statistics in your presentation. We also talked about Europe and Chinese are going ahead in this RET, what you call it. So tell me, how do you think, since in my understanding, renewable energy sources like sun, air, fluids like river, all those are not patentable. What aspect of it is patentable?
Could you please repeat your question? I just didn't get it.
You talked about renewable energy, right? Now tell me what aspect of renewable energy is patentable. So I gave you a scenario. For example, we harness energy from sun or sunlight or through wind or through river stream. All those aspects are not patentable. What is patentable?
So here, when we talk about the patent and renewable energy, sir, it's actually the renewable energy technologies which are used to harness these renewable energies and then use it, store it, or transfer it from one place to another and use them in place of non-renewable energies. Like earlier we were heavily dependent on coal, but now in India, as we can see, that there is no coal left, so we need to now switch to renewable sources of energy.
That is set, no? That is all there already. People know.
Yeah,
we can obtain energy from river or from air, sometimes lightning also. That is all known.
Yes, sir. So here in this presentation, I was highlighting the role of patents, that how the strong IPR system, how they provide and foster the development and diffusion of these.
See, these things everybody know.
Yes.
I know that China is coming up.
Indeed.
Right? I know that a strong policy will develop patent scenario.
Yes.
If you'll ask, the first year student, would a strong policy develop intellectual property? He would say yes.
Yes.
Okay. My question is something else, because I've seen your presentation and you've told Europe is coming, China is coming. All that is fine.
Yes.
What I'm asking is something very legal. It comes under Section 3 of Patents Act. I'm asking you, nature has given you everything free.
Yes.
Okay. Where exactly the human intervention, I'm now giving you hint, where exactly the human intervention will cause a thing to get patentable?
So I think it's just the technology which we can get patented and use it.
Now you talked about some of the regional policies and regional endeavors, particularly with respect to Europe. One of the slides, your slide was talking about regional policies. Have you researched about what policies are there? Because you have not elaborated on policies, you have simply related that regional policies. Do you have some examples?
Sorry, sir, I haven't researched more on that. It was just...
Okay. Nothing about inter-religion transfer technology policies, nothing of that sort. TRIPS is an agreement.
Yes, sir.
Any elaboration on TRIPS?
Sir, trade-related
how TRIPS help in the patent generation process? Can you elaborate that?
Sir, trade-related aspects of an intellectual property rights agreement, like it's basically an international agreement which was made between the countries to for the protection of patent and copyright.
That is there for protection of everything is there.
Yeah.
That I understood. How it helps in propagation of intellectual property?
Sir, it provides like different provisions for the protection, for the administration, and I think all the aspects related to intellectual properties, like talk about patent corporation treaty. I think PCT is there, and that's all I can say.
Okay. Let's talk with Jasbir now. Jasbir, you're also a lawyer?
Yes, sir. I'm a fourth-year law student.
Great. Okay, your topic was granting IPR protection to Fintech.
Yes, sir.
Now you've talked on very interesting topic and I honestly should admit that it was beyond my visualization that Fintech can also be a concern for environmental issues. Thanks for pointing that out. I'm not very in agreement with what you said, but to the extent of consumerism, I agree that it may happen. But rather than looking into the number of credit cards that is being issued, we have to look on the smoke coming out of industry and the plastic and the Chinese plastic in the market. That would curb the pollution and environment to a lot of extent. But yes, it gave me a perspective which is important. In academics, a perspective is very important. It helps us also as a practitioner. So thank you very much for that. Now my question is, Fintech has an issue with patentability again. Can you elaborate that? Fintech, if you research on the patent aspect of Fintech, one aspect of it is, prohibit patentability. Can you tell me what that aspect is?
Yes, according to Section 3 of the Indian Patents Act, I suppose you're talking about that, computer algorithms, etc. are not patentable. However, I was also researching on the same, and I looked upon the trend today that's coming up with granting patent to fintech and to computer algorithms specifically. So the Supreme Court has been granting certain patents, though I'm not sure of the case names as of now, right now. But what I read was, if the algorithm was considerably new and followed the novelty, etc., then even algorithms, despite their being prohibited from being patented, they were allowed to be patented. And this is the coming trend. So that's what I read upon, sir.
Okay. Now you said that Supreme Court has been granting patents. So can you give me some example where Supreme Court has granted patents?
So no, not the Supreme Court of India. What I meant was that the patents are being granted. I apologize for my
grants patent?
So the Indian Patent Authority.
Okay. Now, do you have to say anything about the business aspect of it?
Sir, could you elaborate a little?
Can the business aspect of fintech be patented?
So what do you mean by business aspect?
Okay. What do you understand by fintech?
So fintech is the new innovations, the new technologies that basically financial technology, which brings mankind away from paper money, basically.
So there has to be a business behind it?
Yes, sir.
Yeah, only over that business the technology is developed?
Yes, sir.
The technology part is computer, as you said?
Yes, sir.
But then there has to be a business part of it?
Yes, sir.
Which will give you money?
Yes, sir. Yes,
which will
sir.
give the fintech money?
Yes, sir.
Is that part patentable?
So I'm not researched upon this, upon whether the business aspect is patentable or not.
Okay. Okay, let's come to Bandhana.
Oh, yes, sir. Good evening, sir.
Hi. You've talked about constitutional morality. You went through various provisions and various articles of constitution. Can you tell me a country where the IPR is also one of the constitutional rights? Apart from India, you said Article 300A, and we suggest that is not debatable matter. But let's see. Any other country where it is quite clear that constitutional right provide IPR protection?
Sir, I'm not very sure about it, but while researching, I think not as per constitution, but while reading on European Union, I think they have mentioned about intellectual property rights to be safeguarded as a constitutional right. So I'm pretty much not sure about it, but definitely I will get back to you with this answer. I'm so sorry about it.
Okay. What is constitutional morality?
So it's
in your understanding.
Okay.
Because you have related all the fundamental rights and the rights under Constitution with the economic consequences, and then you have tried to relate it with the IPR. Yes. You have not covered aspect wherein, in biotechnology patents, people are trying to get monopoly on mammals or animals. Even talks are there whether we can patent humans or not after their genetic intervention. So I think these aspects should also get covered when you're talking about constitutional morality, because it is very much covered under the Article 20, and it should part a very prominent part of your presentation rather than just the economic aspects.
Absolutely.
But some of the, even Section 3 of the Patents Act would say that anything which is contrary to morality should not be patentable, and I think these aspects are one of those aspects which should get covered.
Yes.
So it was just a suggestion, although the economic rights, it obviously directly translates into IPR, and it is very easy to relate that, but these aspects should also get covered. What do you think, what do you mean by constitutional morality?
Yes, sir. So I think in some whatever limited knowledge I have gained so far on constitutional law, I believe that it's something that has something to do with the upholding of the constitutional aims and objectives, to meet them through the instruments of what the society or what the general public demands as being a part of this country from the law of the land. So it is about upholding what I it's more of like individual interest as well as the collective interest that has to be secured together and accumulate together, and that's how constitutional morality works, through the means of different types of cases that come up and innovations in the judgments, which eventually holds the constitutional principles as well as the individual and the societal moral values. That's what.
See, when you talk about constitutional principles and constitutional values, whatever terms you have used in last 30 seconds, now all these are covered under Part 3 of Constitution or Part 4 of Constitution?
Part 3 of the Constitution and a small part on the Part 4, that is directive principles. Like it's a blend of.
You did not cover any point on fundamental duties. Nobody's bothered about fundamental duties. These are duties, right?
Yes, sir, definitely. Like these are some principles that has to be followed by the state while upholding certain policies for the country. So I mentioned in the geographical indication part where Article 38 makes a mandate for, I can share the PPT in case you want to see. So it mentions a form of like an economic justice that is to be provided, because I'm from the state of Assam. So our state has a GI tag on the the Muga silk of Assam. So we have seen that there is a small town that is known as Swalguchi, and it solely depends upon the production of these GI goods of Muga silk. So there is also an economic justice that is prevailing in this country, and the government as well as us being maybe one among us will be some public policy persons who should definitely take into consideration of these small poor people who might be sidelined because of the not granting of proper protection of GI scrutiny. That's what I believe, sir.
Since you have touched upon Constitution, is Part 4 enforceable?
Part 4 is not enforceable, sir, but as far as...
Was there any amendment in history of Constitution which tried to enforce Part 4?
Yes, sir, right to free legal aid.
Sorry?
Right to free legal aid.
No. I'm asking something else. I'm asking, was there a constitutional amendment which said that the Part 4 cannot be challenged if Part 4 is sought to be enforced? It cannot be challenged on the ground of Article 14.
Sir, I would definitely.
Definitely answer me. Chalo, forward. Next.
Sorry. Thank you.
Bhashvi, am I pronouncing it right?
Yes, sir.
Yes. Okay. Bhashvi, good presentation, I should say. I'm just giving you some of the points. You have covered Swiss type claims.
Yes, sir.
What do you know about it?
So basically, Swiss type claims are those claims where the compound is already patented, but a new property or new use of that compound has been discovered. So these kinds of patents are cannot be patented under the current patent law, Indian patent law.
Okay, is it patentable anywhere else?
I have no idea about this, but in Indian context, it do not fulfills the criteria which ordinary patent requires. So that's why they are not patentable in Indian context.
You're also a law student, right?
Yes, sir.
Which year?
4th year, sir.
Okay. All right. I think I have nothing much to ask. A good presentation, and you also told that in utility patents or Jugaadu patents, we can get rid of one of the criteria of patentability. Which one was that?
Sorry, sir. Can you repeat?
We can, in utility patents, we can get rid of one of the criteria for patentability. Which was that?
Get rid of which category, sir?
One of the patentability criteria. Amongst novelty, inventive step, industrial application, I can get rid of one of the criteria. Which one would be that?
Sir, I am not able to understand the question.
Yeah, because you have answered that, but you're rightly not able to understand. So let me just give you again, ask you again. In the 3 criteria of patentability, novelty, inventive step, and industrial application.
Yes, sir. Okay?
Which one is not required to be satisfied before an exam?
Ordinary knowledge, sir. Oh, sorry, professional knowledge, because ordinary knowledge can also be granted these
If
days.
I go again, last time asking you, if I go before an examiner, I say, sir, this is the Jugadu patent I have. Which criteria he would not examine? Novelty, inventive step, or industrial application?
Industrial application, sir. If it's a novelty.
I think you answered this in your presentation. It is
Is it
inventive step.
inventive
You would not
step?
look into inventive step.
Yes, sir. Yes, sir.
You would
Now
look into
I get.
whether it is a new invention. Yes.
Yes.
Does it have industrial application? Yes. He will grant the patent. Right?
Yes, sir.
Chalo.
Thank
Next
you, sir.
is Anusha Mohapatra.
Yes, sir.
You're also a law student.
Yes.
Which year?
Fourth year.
Okay. Good presentation, Anusha. One of my favorite topics. I work on this topic every day. I'm disappointed from one fact only. I think you have not looked into any Indian judgments pertaining to open source.
Right.
There's a judgment by Justice Valmiki Mehta from Delhi High Court. You should look at that judgment. It talks about Android and exhaustion of
Right.
patents. So look at that judgment.
Okay.
Now tell me, you said that open source is not a free software, right? It is not free. In what sense it is not free? I think you evaded that, but you simply said that it is not free in all aspects and you just carried out your presentation. I want to know more elaboration that how an open source, when an open source can get patentable despite the fact it is an open source, and how it is free or how it is not free. Can you elaborate that?
Sir, so as per my understanding, if you monetize it, if you put a charge to it, then it is prone to being a chargeable software. I've worked on the copyright aspect of this, so I do not have any clarity on the patentability of it. But I know I worked on classifying it as literary works under the copyright act.
Can the open source software be also patented?
So, as per my understanding, you need novelty, industrial application, and inventive step. And
how is software patented? What is the concept of a patentability of a software?
so I have limited understanding, but I know software patents. I know computer programs cannot be patented, but in India, software patents are also not permitted. But
when you open your laptop, you use your Windows, it says copyright, right?
Yes, sir.
Microsoft copyright. Have you ever noticed that?
Yes, sir.
Okay, it does say that. Look into it. My question is, if I'm making a software, say I'm making a business on fintech, right? I'm making a business on fintech and it is doing a very efficient transaction.
Right.
Okay. So can I have two applications, one for copyright, one for patent?
So sir, for the source code you can get it copyrighted, but then I think for the technology you can get it.
What is the technology? When a software is said to be a technologically enabled software? Can you give me any example of any software which is technologically enabled and can get patented?
Is the Airbnb app a software patent? Would it be?
What is an Airbnb app? I know that it's a hotel thing, right?
Yes, sir.
I am a lesser mortal. Yeah, give me thoda less fancy example. Your Uber app, your Zomato app, can those have? Okay. So the thing is that open source software, the source code is open, okay. But if you're trying to make something out of that source code, like sun is free, I earlier discussed, river is free. But when I'm putting a turbine into the river and trying to harness that energy,
Right.
that part becomes patentable because I applied a technology, a technique. Technology
Right.
comes from the word technique.
Right.
When I'm applying a technique and getting something out of which,
Right.
maybe by using free sources, that things become patentable. Similarly, words are free, letters are free. However, when you design those words and letters into a novel, it becomes your proprietary right.
Right.
So it doesn't mean that if something is free, including open source or everything, when you try to design it yourself, I mean, you put it to give it a structure, then it becomes a patentable or copyrightable matter. And this is also answer to the question I asked to Ms. Shruti. Okay, so when solar energy is there, I am trying to harness that energy through silicon. Okay, or if from silicon I am transferring it to some other system, that transmission can itself be very inefficient because solar cell transmission from solar cell can become difficult. So when I am putting any human intervention and trying to get this free energy from nature to various systems which are very efficient, then it becomes a patentable subject matter. Similarly, for the words, copyrightable matter. Okay, these two are completely different domain. These are two different subject matter. So a parallel application for copyright and patent exists. It can happen. Only there is conflict between design and copyright, which you would know when you will study Design and Copyright Act. The Design and Copyright Act some overlapping areas, and therefore Design Act prohibits the copyrightability of a particular design. I think this is it from my side. Harshal.
Thank you for your input, sir.
Thank you, sir. Thank you, all the panelists. Thank you, sir, for your insightful words and questions. Now, I would like to ask Murthy, sir, if they have anything to ask to these panelists.
Right. Anyhow, I already remarked for all these independent presentations previously, but still, again, they carried as such our guest today identified some of the students' expression views. But Vivek Ranjan, I also want to bring it to your knowledge that these students are not IP specialized, but they are generally studying the general honors, and by that way they are having interest. They don't have scope for excelling themselves in IP specific. That's why they are coming to these platforms and trying to protect their indigenous interest to excel the subject to an extent. But somehow I also kept silent for the reason that let me check their braveness to sustain for the given tussle, how much they are able to sustain, but they are able to retain. So that's a good thing. I feel happy with these students. They are courageous and capable to stand whatever questions is technically being asked. They able to try to answer up to their level rather than give up condition. That's good.
So, sir, let me just to add to what you said. We as an advocate, we practice before High Court. Okay, sir.
Yes.
And when we go before a judge who has got elevated from district court, we are in a very state of fear. Because what question he will ask from, he is expert in CPC. I think judges are not expert in CPC.
Yes.
So this kind of experience wherein you feel, okay, oh my God, you are going to somebody who's expert in this particular law, and you're just an advocate practicing at High Court and writ jurisdiction and appellate jurisdiction and all of that. So this is a different experience, and this will bring a lot of learning to them also, sir.
That's good. That's why I allowed, and they must experience and they must learn that subject depth is so much, because now they are already top of their 5 members. They already selected from 1,000 members. Out of 1,000, these 25 were selected. Out of this 25, then again each 5 members, the domain specific, like 5 categories, they were assigned, and within that 5, again they were stood top. So by that way, they are meritorious in a way. But subsequently, in that meritorious condition, they have so many challenges ahead also need to be understood is the exercise proven and learned by them personally with practical experience. For first point. And moving ahead with second part, like to quoting different aspects, like say Shruti Kukreti, you presented with wide information. But see, when you were giving because I am critically pointing out the presentation rather than general appreciation. So don't think otherwise I'm just only making a critical view. general appreciation I already completed and appreciated. There's no question of it. But over that, the critical view I'm providing today for your expressions. See, you studied different material, but you didn't correlate the material in a line and making the flaw or fault, because different organizations make different reports. There is a contradiction also, there is an intersection also, there is some interrelation and some conflict also in that understanding. So you didn't, when you study thoroughly and make a line of its understanding, then only you will get a summarization. So that summary learning is not a very quick learning process, but you must keep in mind while making from here and there, and like ready-made cooking process is different, and the traditional taste making process at home is different. Ultimately, end of the day, healthy, homemade, traditional cook is the ultimate, right? But this fast food making, like in a center where what is that Chinese fast food or XYZ, you will making a what is that professional skill display rather than a taste protection and health protection condition. So this is one point. Yes, that performance also attracts at least one plate of that serving. That recipe can be sold for a minute. But for your point of view, consumer point of view, you must have the total understanding and skill in all dimensions. Then only you can make the changes according to the requirement, rather than whatever you know must be sold. Market will not receive all the time. Right? So, but at your preliminary step, that is good, but subsequently, you must have a thorough understanding and coverage of each individual subject and their connectivity in good terms, and by that way you will be having a concrete understanding. Then you will not be fumbled at any point of time, right? So that is one point I just want to point out to your presentation. Then fintech protection and environmental issues, Jasbir. So the whole scenario in the drive of the environmental relation is one point. That's a very good and nice art of presentation. But thing is here, the core fundamental aspect of the fintech regulation and IP relations, actually financial technology is not a new thing. It is an existing thing. But the financial transactions working, bringing into the technological working is the modification. So that facilitation able to happen with the invention development and their accommodation of the existing structure into this made the workability even during this COVID condition and other difficulty conditions, we able to survive with all comfortability. This is one of the successful reasons. So that basic fundamental aspect could also be pointed out, and later to that, when we are looking in the good perspective, there is an end of the that Bale perspective as well. But by the same time, it is not the only platform was making these things. The overall summarization, rather than you are ending up that it is a danger is one point. There is a preliminary understanding, but it should not be concluded in the overall learning of the subject presentation. Rather, there are many hazardous conditions. By this way, you are minimizing and saving the reducing the pollution levels, and this will be helpful for raw conditions will be reduced, then society can be well protected. So this is the way how a collective and comprehensive working of this in that 2 degree centigrade of this development. There are 20 degrees development is happening by many other things. Understand? And this 2 degree quantum, 2 degree is not because of this alone. This quantum is of this person. See, that 2 degree increase, 2 degree is the only variation of the whole pollution. Keeping in mind that part, what is the quantum of this contribution out of this 100% 2 degree increase? What is the quantum of this fintech? Maybe 1% or 0.0 so something. What is the percentage? That we must calculate, and this can be alternatively be covered by many other things, and this is reducing other way. Why? No, because of radiation, it is creating some heat generation to the society is one part, and solid waste is generating is another part. But apart from that, it is reducing like this much of paper it might have been, like how much this fin technology transactions is what is that real-timely taken, then how much material, stationary material and other things to be taken care of. So what is that compensation and equation? Because
These kind of literature normally corporate oriented, means a particular industry to promote their product, they will definitely make this kind of, it is better than that. So that is the competitive spirit of each other. But as a social responsible person, when we are looking and making a conclusive statement as a balanced personality, so we must have an approach towards this. Looking into the one way, it is a new thing, and making so much of facility is a big benefit. And by that time, these variation, even though pointed out some community, we must retaliate and mention that yes, this is not such a obstacle, such much it must be stopped and restricted. Rather, it can be overcome by considering the benefits that are reaping to the public in a larger scale. So this is the way how the approach need to go ahead. That is the only gap, and rest of the things are now carried ahead. So that's why I'm saying the line of going in one direction must should not ignore the other angle of its relation. That is one point I able to figure out from your presentation observation. Then next, coming to the constitutional morality and IPR aspect, as Ms. Vivek Ranjan rightly pointed out. So, but thing is here, you also need to study that aspects. Apart from that, if you look in the judicial perspective, the concept of morality is different from that of constitutional morality, what they are segregating in the. Who is that judge after Krishna here, sir? There was one other judge who went to Jammu Kashmir as well. I forgot his name. Uttar Pradesh person, elevated to Delhi and the Supreme Court, and then went to even Markandeya Kaju also in that extent.
So Justice Chandrachud.
I was confused.
Justice Karju, he talked about Mimamsa law. That's what you're saying, sir?
That's what Justice Karju I already mentioned. But one other person also who specifically worked on this constitutional morality time and again in Supreme Court judgments. So that forgetting. But what the reason I am mentioning is Justice Karju very clearly he came up with different aspects, mentioning that this is the way how constitutional morality must respect specifically on the given provisions. If you dig behind the understanding, this is the constitutional morality. You need not separately. Whereas social morality, that means the societal morality, when it is working, it is limited to the practices and the regulation comes, it can be overruled. But constitutional morality, when you bring in, law cannot overrule the constitutional morality, is the conflict. This is the second level of the obstructing condition, like basic framework condition. The constitutional morality cannot be overruled by any legislative framework because that will restrict the legislative development. This thing is the new development. So in that new formation, otherwise in our section 3, as Vivek Ranjan rightly pointed out, there is the land morality, public order morality is the aspect where section 3B is talking about. So in that way, morality aspect where he also rightly pointed that whether chimeras or even other animals making like what is that Anka mouse case and other things where we have these moral issues many. But over and above constitutional morality, now coming up with new angle of its conflicting condition, that is what like now sex toy and other things which were pointed out, which is beyond the moral respect, but now it is filtered under constitutional morality and saying that no further. Where LGBT and other kind of certain things accepted, why not this be accepted is the tussle now pushing the courts to consider. So that way, there now this aspect is making more relevant and required to work the IPR effective. Otherwise, with all technological force, many of the moral aspects are driven out, and by that way, legislative force is facilitating them to bring in. Now, to lock that legislative influence, where industrialists are making the legislative outcome, and by that way, they are bulldozing their interest directly to work upon. So, where now judiciary is locking through the constitutional morality, where the legislation itself is not capable enough to bring such kind of provisions to work out. Right. So this is the way where one, what is that? Sophie
robot. Yes.
Citizenship were provided. No.
Yes,
so providing a citizenship beyond natural person, even animal is not entitled to gain. Where you are going to provide a citizenship for a machine, which is in Indian context, it is not possible to pass through. So there all we were finding this constitutional morality aspect will come and stand obstacle and will not be permitting. That is one of the reason where even today in European Union also artificial intelligence providing it a separate legal entity and providing protection will not be supported. England now clearly come out with that. It should be within the limit of this working. It cannot be with a legal person be protected all this, which was proposed for longer period. So there all the constitutional morality is now coming in support of protection of IPR in a positive way, rather than taking in a technological advanced condition for their benefits.
Yes.
So those aspects could have been taken into account of this working, rather than the few of the material whatever you come up. That is one observation there I put it.
So I will definitely work ahead in future. So thank you so much for your insight. Thank you.
Right. So then next to that, coming to Bhashvi Saxena, talking about constitution. Yes, and Vivek Ranjan specifically pointed out, and you mentioned about only the fundamental right, that is Article 31, and next to that going to 300A. This you mentioned, but he also pointed out later to that there is another provision is there. Can you point out? But you are not able to mention. Is it not? Do you have the provision to express even right now, madam?
So are you asking to me?
Yes, constitutional. This question asked to whom? For you only, no?
No, sir. My was petty patent. So it was.
So then it must be for your Bandhana's.
Yes, sir.
So for you, the thing is, this is there under 8 Constitution List 1 Entry 49, which is covered for patent, copyright, trademark, and designs. So later to that, subsequent aspects were covered under Entry 97. Where entry 97 is open, which are not mentioned, and those aspects will be covered under that. And this way, list 1, entry 49 and entry 97 able to cover all the IPR legislations through Constitution directly.
Yes, sir. Yes, sir. Taking note of this.
And so while doing research on this is the fundamental. Nowadays, the students are ignoring the fundamental understanding of the subject and working on nuances is a dangerous condition. So he must take care, and he rightly picked up, pointed out that aspect, and that's why I'm specifying. Take note of this and make an understanding. Other than this, even property, if that is the case, in extension to that understanding, property will be in whose name? Government means government is the whole community. In the government, like in central government and state government, how the property owned and represented? It must be by one indication and individual. Who is that?
So I exactly couldn't comprehend if you could just.
These all the aspects need to be taken into account. Like government of India, president represents and governor in the state represents any property of the state represented by these people. So this is also you will be finding in subsequent articles. Figure out those articles and just go through with. There are specific articles for this aspect to mention. 254 or somewhere, I'm not recollecting exactly.
Every activity of government is, as sir said, every activity of government is done in the name of president by the central government and government for the state government.
Okay.
Those aspects are very essential to read by yourself and understand.
Yes.
And now coming to Bhashvi Saxena regarding to petty patent. Is it not? This is your topic is
yes,
petty patent, no madam? Regarding to petty patent, you mentioned that it is only utility model patent called as. Yes, majorly been called as utility model patent, but it is a later developed term. Rather than it started with inferior patent, lesser patent, minor patent, lower patent, short-term patent, inferior patent, or these kind of terms. Utility model is the sophisticated term at the later point of time in 19th century developed.
Yes, sir.
Otherwise, beforehand, these kind of developments, and as such, you said that in Germany they worked out on 1886. And in that also, they come up with, I think, shorter patent or minor patent, something like that. Lesser patent, I think. In Germany, started with lesser patent.
Lesser patent.
And as such, you mentioned it is 70 countries, but as per the update of that data must be 10 years old data. If you are able to verify, I think in petty patent now more than 120 countries. As per my understanding, last semester I gave it to one student. He brought it is somewhere around 120 countries are now working, increased. So verify that data and try to look in. Now many countries and data protection also going from a period of 7 to 14 years. Now that 5 years, 3 years period was gone, and those practices are now wiped off. Even and you mentioned in your presentation, Japan also now increased to 10 years. Yes, that is true.
Yes,
So similar way, any country is working a minimum of 7 years, and next to that a maximum of 14 years. So is the condition, and that way they are working. So yes, for Indian point of view, there are works are going on. Hopefully, maybe in coming days we may see the daylight of the legislative development if at all they are positive. But I don't know what reasons they are having the struggle. And statistics are saying that it is essential for the national development and GDP growth and industrial growth as well. It will be, and MSME is also working in that direction, and they have data, and their data also many times recommended to consider this petty patent protection. And I think in coming 1 or 2 years time, it must see the daylight. That is what my opinion. But I couldn't read anywhere that there is an effective drafting practices going on. Reports submitted several times, but later to that subsequent structurization of the legislation and finalization of the legislation conditions, I couldn't able to listen. That is the part of petty patent. And coming to the open source software condition, the observation is, yes, in presentation you mentioned about open source and its working. See, open source and IPR here, when we are looking from IP perspective, this aspect need to be essentially clarified. Where open source means, whether open source, what is the meaning of open source and what is the relation with IPR, whether open source, see, day and light, dark and means the light, darkness and light is two opposite things, white and black is two opposite things, understand? So in that condition, there are some connectivities also to create a black color or reduce the black color darkness down. White only capable to reduce the black down, like lightest shade of the black can be done with the help of white means no working. Similar way, open source and means no privileged protection is two opposite ends extreme, but there is a connectivity and integration. So that is most important to express. Say for example, open source created innovatively, when it is there in even any creative copyright literature also, after the expiry of its protection, it will fall in public domain, open source. Anyone can copy, anyone can work, anyone can, without quoting the author's name, he can copy it, reproduce and utilize for his purposes. But here, the open source, what they are doing, they are creating. They don't want to go for commercialization privately. They are interested to serve it to the public freely. By that way, whether they can have privilege or not is the question coming up. In that situation, what they are doing, even though they created, they are giving it free to the public. So by that way, they are making it as open source. And in that situation, they are making the general license system. What they are doing, this resource is also equally or means the comparatively workable on par with the what is that protected services, like say for example Microsoft. Microsoft is a copyrighted subject matter which was developed with intellectual. Same thing, the other person to crack out and by put it in the public domain by alternative means of its creation was exercised by the other person. He also created, he can go for copyright protection, but he don't want to, and he want to put it in public domain with free of cost, but he made the restriction that any person using it must be identified and licensed, and this way you can work it. And next to that, now that source is open, this is the subject, and this subject is kept open, and he created some contribution of the subject conversion into expression, and later to that subject development. In Linux now, there are many people, many authors are there who are developing day by day. Everyone is making their own contribution of development and adding to that. By that way, it is a collective approach, like trademark and GA. Trademark is one legal entity's protection, whereas GA, in trademark also we have collective mark. One is the collective mark is group of people together working with one identification. Similar way here also, the open source is not meant for objectively commercialization, but providing services in the morality respect. That means in the service-oriented nature without any commercialization. That's why licensing and other concepts were built up over that open source condition. Otherwise, in general understanding, open source means copyright literature expiry period after it will be open source. Anyone can use after expiry. So these two things are having a line of differentiation, and now here the things. Now coming to the open source working in patent platform. Copyright is this part, and patent platform coming in. Open source, and today all the security softwares which are developed, computer program to software working. What is the difference between computer program and software patent? Mere computer program is still limiting to the line of expression, which is limited to the logical relation of its functioning, but limited to the literary form of its protection. Whereas beyond that, like he rightly pointed out one aspect, give an example, saying that any functionary, fintech, whether transactions, business transactions taking in and working like that, otherwise ATM working with, or what is that, blood sugar levels testing equipment. So these are all not mere software, mere computer program, rather beyond computer program means more than computer program. What it is happening is doing the functionality in attachment with the computer program and carrying the functionality. That's why the integration of functionality with the hardware and the computer program together able to, that was the first transition stage, where the computer program, mere computer program elevated to the level of more than computer program. That more than computer program with integration of any hardware means the device, and their inseparable software is part of that hardware, and there in that position it used to protect. But from last decade to this decade, when the shift taken the dimension either by Alice case or other cases which were provided one level of other interpretation is not necessary, like business method patent and software patent things. Here the developments are happened where it is integrated from the existing system in a differently functioning, like today we are having Instagram or what's the Telegram software or Uber. Mr. Vivek Ranjan rightly pointed out Uber and Ola or whatever these network marketing softwares which are not doing only the software, interaction is also different other tools like mobile. When you just make a message goes to the person and person gives the code OTP to the person, then you enter it. These are all interfaces happening. When these interfaces are happening between, this thing is beyond your computer program. So that's why here these things are one level above the condition of mere computer program. That's why they are under software patent. Their functionality respect is protected under that. So this is the thing where you must interrelate the open software or the paid software, how these things are built upon. Even paid software, whether it is Mac or Microsoft or any other software, they are also working on some of these open source platforms connected to, but they were other way built up, superstructure was built up separately, like apartment. When you just construct from one foundation and on the terrace, if you go for penthouse and other, like with the top floors, each floor is having its independent right. And first floor may be the person who procured, he may be using for the purpose of some service purposes, so that way left for public to utilize, but it must be followed the apartment regulations, right? So similar way here, the open source relation with IPR should be worked out and expressed in this line that need to be taken note of. This is my observation for your presentation. So this is what about all your 5 people's presentation observation. Thank you.
Right.
Yes,
Thank
now,
you so much, sir. Yes, sir. Now I would like to call upon the keynote speaker for today's symposium, to give a general address to all the audience. And then towards the end, Vivek sir will get the best presenter for the symposium.
yes.
Vivek sir.
Thank you very much, Harshal, and thank you, everyone. You have put in nice efforts, and it shows that these kind of competition and this kind of presentation, they will prepare you for your ultimate target of being a lawyer. You face all these questions, and in a lawyer's life, every day is an examination, every day is a viva. You have a tough judge, you have a nice judge, they ask you question. You should not just only be well versed with your file and the facts of the case, but also the law point. Because particularly in IPR, wherein the judges are not that well equipped, when you go before a judge who is dealing with IPR matters first time, he would ask you question, he would try to understand what is patent law. So typically, or copyright law, trademark law for that matter. So typically, what we do is when we go before a judge, first 2 hearings of 2 hours each, we take to teach him patent or copyright, that this is how it governs, this is what the Patent Act says, and then he asks us questions, okay, based on our understanding or our arguments. So this is very important. All these things will prepare you and will tell you that how to move further, how to be a better lawyer, how to be a better, arguing counsel or a researcher or corporate counsel, and what can be the issues that can come even in your corporate lawyer life. Okay, so all the best, and you all have done very good from your from the point of view from where you are right now. You're all students, you're all learning. One thing I would just say that whenever you're preparing a research work and whenever you're preparing for presentation, it is very important, like Murthy sir also said in the beginning, it is very important to point out to a problem which is existing in society. You only want to do research for the problem which is existing. Is that problem really worth researching? That is very important, all right? So just point out that problem, and it should be a problem. It must sound like a problem. And if it is not sounding like a problem, the data should suggest that it is a problem. Okay. And then solution to that, even a short-term research or long-term research to that particular problem is really what doing work at. So it is very important. All of you have, from your perspective, have pointed out that problem. And as I said, some of the presentation has also given me a new perspective, like that fintech presentation. I never knew that fintech is such a huge problem for environment. I was thinking all this time that fintech is it is an environmental friendly technology. Everybody is doing their thing from phone. At best, electricity is required to charge the phone. This is it. But yes, as I said, Jasbir, to certain extent, I don't agree. But then some of the factors like consumerism, it has really opened my eyes and tried to look into the fintech from a completely different direction. As I always say, these things always help practitioners like me before the code, because these perspectives are really important. So thank you very much. And I've been given a huge task of announcing the winner. So, I like a cliche, I mean, although true, that everybody has done very well and everybody has put in their best, but I have to choose one very difficult task for me, and I actually made an elaborated note on how to judge that. So, Harshal, do I really need to do that? Murthy sir is senior to me, he should do that. I think you should communicate him and he should do that.
I did 5 times for Miss Nojo for past 1 month period. And regularly, even for making their research papers, they must do, every student must do 2 research papers and 1 case study. So that way, multiple times I carried for this 1 month thing.
Okay. All right, sir, I'll lower your burden this time then. Okay. I think Bhashvi has done quite well, and she has stood amongst all of you. I would rate her number 1, but rest of you comes under within the bracket of 1 or 2. There is no 3, 4, 5. So applause for everyone. Good job, and congratulations, Bhashvi, for your presentation. All the best, and keep doing the good work. Thank you.
Thank you, sir. Thank you very much.
Thank you, sir. Congratulations, Bhashvi, and all other panelists, of course. Now, to conclude this symposium, I would like to ask Udit, who is a second-year student and editor at CSRIPR, to conclude the program with the thank you note. Udit?
Thank you, sir. First of all, I would like to thank everyone, one and all present here. More specifically, Vivek Ranjan sir and Murthy sir. We are our students, and we might have a lot of time at our disposal, but you two are busy people. But still, you took out your time and came to this symposium. Since this is the last meet for this ongoing internship we are having at CSR IPR, so I was.
No, this, Udit, was it audible?
Uh, I think I lost the connectivity right that moment. Can you please repeat what you said?
I said this is the second last meeting that we're having.
Yes, sir. Yes,
Last
sir. Sorry.
meeting is tomorrow.
I missed that. Yeah, so this is the second last meeting. So it is one of the concluding moments of the internship. And I would like to firstly thank the whole team of CSR IPR for making this thing possible. I would like to thank Murthy sir, who is the faculty convener of the center. I would like to thank Harshal Bhale sir, who is the student convener of the center. Then I would like to thank Pritesh sir and everybody else who's behind the curtains and doing all the work, all my fellow students. And most importantly, I would like to thank all the members who signed up for the internship, who got selected, who are not here. Some of them didn't get selected, they are not here. And the five panelists of today's discussion, Ms. Shruti Kukreti, Ms. Jasbir Reid, Ms. Bandhana Saikia, Ms. Bhashvi, and Ms. Anusha. And I myself, being a second year student, I am not well acquainted with the subject of IPR, but I got to know that it's something which is very interesting. And to the best of my knowledge, I learned a lot of things from you people. And the center itself, on behalf of all its member, wishes everybody present here right now as the interns the very best of their lucks in the future. And again, I would like to thank Mr. Ranjan and Mr. Murthy to spare their valuable time for this initiative we are going through with. Thank you. Over to Harshal sir.
Yes, thank you, Udit. And a big round of a thank goes to Vivek sir for coming out here with and giving his time to all of us. And every time we ask for any of his support, he never says no. That's the one thing that we really appreciate. I, on behalf of the center, would like to thank you for that, sir. And would like to collaborate on the future upcoming events that are going to take forward. And thank you very much, sir. Thank you very much.
From
All the
center side, I also express my heartful thanks to Mr. Vivek Ranjan, because whenever at last hour also we request, he able to, without any second thought, he gives his positive sign. That is a great support for us to all the time working with him. It's a very great pleasure with working with him. His association makes effort more improved in a condition. That is one good thing. What do we benefit out of him? That is the quality of his contribution. Whenever he comes, whatever conditions are there behind, but his contribution will be definitely adding value to the program. And
Thank you for your kind words, sir. Thank you very much.
And we expect the same cooperation in further.
Sure. Needless to say that, sir.
Thank you, sir. Thank you, Murthy, sir. And I would like to thank all the panelists for coming out here. Not only the panelists, but also the other who could not get selected, because we have this process that we follow. I know it's not a good thing that to, choose one student out of the five, because all of the five have done their level best to come out here and to give their presentation. And one concern that all the students have raised was the fact that we have a very limited time to prepare for a presentation plus research paper and all the other tasks that the center gave to you during the course of your internship. But that is how an internship should be, right? That is how a law student learns how a law works in the practical world. You will not get hundreds of days just to file an application in the patent in a high court or say in a Supreme Court, wherever you go, as Vivek sir rightly mentioned. So I hope you all have learned few things about IPR during the course of this internship. And I would like to thank, yes, and a big round of applause goes to the team of CSRIPR who has worked really, really hard to make sure that every review, every task that is being allotted to you and that has been submitted to the center is being reviewed every time possible. And the last article that you guys submitted could not be reviewed due to a lot of submissions. See, we have an official log of CSRIPR where we receive a rolling submission, right? So we have thousands of students who are waiting for their review, and they are waiting to get their article published. So that's why it takes a lot of time to review even a single article, because we are official log. It's like an NLU log. It has its own criteria as to how it should go onto the on a vlog. So there are a lot of things that's to be taken care of, and that is being taken care of by the team. Which and the update regarding your review will be given by the latest by tomorrow in the last meeting that we'll have tomorrow. And yes, I would like to congratulate Bhashvi for the great achievement, and also all of you guys, you presented really well. So thank you so much.
Organizing team, every member, right from first year or second year students whomsoever joined to till PhD candidates, where the Tanisha and Yash all the time. I think in many of the panels, Yash was continuously there, and in one or two times, Tanisha was also providing support. So that way, every level, from first semester to PhD level, every student is contributing their services, and fourth year students also, that three students specifically, or four students. Yes, those four students, they were contributing. So likewise, every batch wise, people are Pritesh and you are working from the beginning. So contributions, it is not one person effort. That is what I mean to say. It is a consisting of more than 20, 30 members or 40 members team. We are on board. And out of this, more than 20, 25 members continues. Like 25 members interning means each person is backed at least minimum one person. It is a composition of two persons backup, but at least a minimum of one person all the time was backed up, provided back-end support, and by that way the service able to successfully come.
Right. Thank you so much, guys. And it's been more than 2 hours that we are here continuously before the screen. Your camera was on. I can see the tiredness on your face. So thank you so much for bearing with us. If anybody has anything to add, you can do it right now, or else we can conclude this meeting here. Anyone? All right then. Thank you, sir. Thank you, Vivek, sir.
Thank you, everybody. Take care. Bye, sir.
Right.
Thank you, sir. Yes, you all can leave, please.
Thank you, sir. Thank you, everyone.
Thank you, sir.
Thank you.
Thank you, sir.
Thank you, sir.